Court of Appeals in and for the Fifth District of the State of Florida is now in session. The Honorable Rand Wallace, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session for the 5th District Court of Appeal. I've been previously introduced. I'd like to introduce the other members of the panel. To my right and your left is Judge Jay Cohen from Orange County, and to my left and your right is Judge Meredith Sasso, also from Orange County. We have two cases on the docket. Before we get started today, I'd like to just ask everyone in the courtroom to please silence any phones, cell phones, or iPads or anything that may make noise during the oral argument so it doesn't distract the parties giving their presentations. We have two civil cases on the docket. Both cases have 20 minutes. I'll assume the appellant wants 5 minutes for rebuttal unless you tell me differently. And the first case on the docket is State Farm. Actually, both cases involve State Farm. First one, State Farm versus Brian Gold. And you may proceed when you're ready.
May it please the Court, Elizabeth Russo on behalf of the appellant State Farm, Florida Insurance Company.
Good morning.
This appeal involves an issue of insurance contract construction. The policy to be construed is a personal liability umbrella policy, and it's in particular, it's the uninsured motor vehicle coverage that's at issue here. Review is de novo, so it's the policy language that's going to be important. The specific issue is whether the uninsured motor vehicle coverage of the umbrella policy applies to cover an accident with an uninsured motorist that occurred in Nicaragua.
Was the uninsured motorist policy actually already incorporated in the umbrella policy, or was it a separate policy that was obtained by the appellant?
It's a separate underlying policy.
Okay, and how was that policy identified in the umbrella policy?
The umbrella policy provides that in the uninsured motor vehicle coverage section, it says, this coverage applies in accordance with the terms and conditions of your underlying uninsured motor vehicle coverage. And that I filed both policies as an appendix to the initial brief, so I'll just refer to the appendix pages. They also show the...
Do you understand how someone it could be unclear to someone whether the parties intended to incorporate the entire underlying policy into the umbrella policy, or to incorporate only Section 3, which dealt with the uninsured motorist benefits?
It says specifically that it's in accordance with the terms and conditions of your underlying uninsured motor vehicle coverage. And there is in the underlying policy a section of uninsured motor vehicle coverage.
But Condition 5 doesn't describe the underlying policy, does it?
I think it does, because it provides that it's your underlying uninsured motor vehicle coverage, and your in the umbrella policy is a defined term. You and your are defined terms. The umbrella policy defines them as, in this policy, you and your refer to the insured as defined, and then insured as defined is insured means the named insured and also the following residents of the named insured's household, the named insured's relatives. There's no question, and never has been, that Brian Gold was a resident relative of the named insured, which was his parents.
Is there any prohibition for the appellee in this case to have had multiple uninsured motorist policies?
I'm sorry?
Is there any prohibition or is there any limitation as far as the number of uninsured motorist policies that the appellee could have had? When you just say your uninsured motorist policy, how do we know that we're not dealing with multiple uninsured motorist policies?
I don't know that anybody ever buys multiple uninsured motorist policies.
I don't know that they do either, but this doesn't reference, you didn't attach the actual policy to the umbrella policy.
No, but I think the reference to your, and I would also point out that it was never questioned below that Brian Gold's uninsured, his underlying auto policy was the underlying policy being referred to. And in fact, plaintiff's summary judgment briefing identified his policy as one of the underlying policies, and at the summary judgment hearing, he asked to have it marked as such, and that appears at R2472. This was never, ever an issue, and he had it marked as, this is the underlying policy, I want it marked as such, at the summary judgment hearing. So I think that it's clear in saying unless they had come forward with other underlying policies, which they never did, this is the only one that's ever been here, and the umbrella policy is clear in saying your underlying motor vehicle coverage.
So if it is clear, and it seems like the trial court identified the underlying policy, but it seems the trial court focused on the conflict that was created, or the perceived conflict that was created with the duties to us provision. So why, in your view, is that portion of the policy not necessary to review in light of the perceived conflict that's created with the coverage U provision?
I'm sorry, I missed the first part of...
Sure, the language and the duties, your duties to us portion of the policy that suggests that if you fail to maintain the underlying coverage, that you're just responsible for that portion of the payment, but that there's still coverage for anything over and beyond, versus the language in the coverage U provision that suggests that, in the language of the Israel court, the policy is vitiated if you fail to maintain that coverage. Why is that not a conflict that's relevant to this analysis?
Well, there was a completely separate argument being made below, a separate coverage argument as to why there wasn't coverage, and that had to do with that business about maintaining the underlying coverage and what were the consequences if you didn't. And as Your Honor points out, there was one consequence specified in the duties, your duties to us, and a different consequence in the uninsured motor vehicle coverage section of the umbrella policy, but we're not raising that on appeal. That would be, if we were right about that, we think we were, but the trial judge disagreed and found an ambiguity there, which fine. But that would be, if that had been raised, which we are not raising in this appeal, that's just a completely separate reason why there wouldn't be coverage. It has nothing to do with the territorial limitations.
Your argument, though, for raising territorial limitations is that because this fell outside of the territorial limitations in the UM contract, there is not coverage, period, under the policy, right?
Right.
But couldn't, as the trial court determined, if you fail to provide, or if you fail to comply with the territorial provisions, or if it falls outside the territorial provisions of the UM policy, you don't have coverage for that UM portion, the underlying UM, what UM would cover, but that the umbrella policy still kicks in for any amount over and above. Isn't that the conflict that the trial court saw in determining that there was coverage in this case?
I don't know. I didn't get that from, I read that hearing transcript where he was explaining his reasons, but I never got from him what he saw as being an ambiguity in the territorial limitations.
And I don't think he saw the territorial limitations as ambiguous. It seemed that the trial court read the territorial limitations provision, but said, even considering this, that there is a territorial limitations provision in the UM policy, the question that you presented was whether the umbrella policy provides coverage. And I think the trial court found that it was a global policy in the sense that there was not territorial limitations in the policy, in the sense that those territorial limitations were not incorporated into it because of these various other conflicts. So in your view, those are completely irrelevant.
Well, I think that he was wrong about that. It's true that the umbrella policy does not itself contain territorial limitations, but that's because it has other coverages, like personal liability coverage, that it wasn't placing territorial limitations on. But by saying, it plainly says, it applies in accordance with the terms and conditions of your underlying motor vehicle coverage. Now, unless you're going to just erase that out of there, You have to go look at the your underlying uninsured
It
motor
also
vehicle
says, though, at the
coverage.
end of the coverage you page, doesn't it, though, that every other term, or something to this effect, every other term of this policy applies?
Yeah, right, but except for what we've just listed. And one of the things we just listed is, we're giving you this uninsured motor vehicle coverage in accordance with the terms of your underlying motor vehicle coverage. I don't see how that could be more plain. Because, especially with the definition of you identifying whose underlying motor vehicle coverage, and then we have the underlying motor vehicle coverage of Brian Gold's, and it has territorial limitations on it. The territorial limitations, I know counsel has said, well, that's not actually in the underlying uninsured motor vehicle coverage section, but it's in the beginning of the policy, and this is something else you would have to erase altogether. It says when and where coverage applies, and for where coverage applies, it says the liability, comma, medical payments, comma, uninsured motor vehicle, comma, and physical damage coverages you chose apply in the United States and Canada, basically. So you would have to erase that out of the underlying auto policy because it's saying here's where your uninsured motor vehicle coverage applies.
So you would agree the trial court found the policy ambiguous, right?
I'm sorry?
You would agree the trial court found the policy ambiguous?
Yes, I do, yes.
And in your view, what was the basis for the trial court's ruling that it was ambiguous?
I think just saying a policy is ambiguous is, what portion of it is ambiguous? As I read
and that's
it-
what I'm asking. What is your understanding of why the trial court, what portion of the policy did the trial court find ambiguous?
I'm sorry, Your Honor.
Yeah.
I think that what he found ambiguous was the provisions about your duties or requiring the insured to maintain underlying insurance. That was a big debate below and took up a lot of the argument sections and everything. As I say, we're not raising that. But he thought, as did that Israel case that's been cited in the briefing, he thought that because your duties to us say you must maintain your underlying insurance or you're going to be responsible for that underlying limits. Whereas the uninsured motor vehicle coverage section says you must maintain your underlying limits or this coverage will not apply. There's two ways that you could look at that, but since he decided that it was ambiguous, the argument for it not being ambiguous is that it specifically said this coverage, meaning the uninsured motor vehicle coverage, will not apply. But anyway, we're not getting into that here. We didn't raise that issue. But
And that's what, I mean, you obviously saw the waiver argument and the brief. That was the basis for the trial court's ruling, so how can we not get into that?
Because that just means that, all right, then you don't have a coverage defense that they failed to maintain their underlying insurance. Fine, we don't have that coverage defense. But we have a coverage defense that the accident occurred outside the territorial limits. That's completely separate reason why there is no coverage. The ambiguity finding as to them maintaining has nothing to do with that. And the trial court didn't identify or say, really, that there was an ambiguity in the territorial limitations. That's all that we're saying, is this is outside the territorial limits of the UM coverage that was afforded by this umbrella policy, giving effect to all the terms.
So I guess, is your argument then that the territorial limits and the underlying UM policy was incorporated into the entire umbrella policy, or only that coverage you provision?
No, only into the uninsured motorist coverage section. That's the only one that said that it was
And so then,
incorporating
then
it.
the next step, I guess, would be what is the consequence of failure to, for an accident that occurs outside the territorial limitations and therefore failure to maintain underlying UM coverage, right? That would be the next question.
No, the failing to maintain the underlying coverage really has nothing to do with the argument that we're presenting here. We're just saying there's territorial limits to this coverage. This accident took place outside the territorial limits, period.
So
Doesn't mean that in addition you may have failed to maintain your underlying. That would have been a different, separate argument that was argued over below, but we're not raising it here.
But if the accident took place outside of the territorial coverage, that means that there was no coverage, and therefore the appellee didn't comply with the required coverage under the umbrella policy as it concerns uninsured motorists, correct?
Well, it's probably also true that because he didn't get coverage for being in Nicaragua, there's some argument about, okay, and there's a policy provision that required you to maintain your coverage if you were going to travel, and you went to Nicaragua without getting Nicaragua coverage, so you don't, for that reason, you're not covered. That was argued below. I'm not arguing that here. I'm just saying this policy, the umbrella policy, when it incorporates the underlying policy by saying it is applying according to its terms and conditions, the underlying policy specifically has territorial limitations, and so it's saying if you get into an accident with an uninsured motorist out of Canada and the United States, it's not covered. This policy does not, this coverage does not apply. So it's the mere fact of having the accident in Nicaragua that meant, okay, it's not covered. Because that's what the policy, I think giving effect to all the terms and not erasing any of them out of there, that's the bottom line.
And so I guess when you say not erasing any of the terms out, that's when I'm having a hard time understanding why we would then ignore the your duties to us provision that talks about the consequences of failing to maintain coverage or for accidents that happen outside coverage.
Just because I think that's maybe it may or may not have been a separate duty that was breached by the insured, but that really doesn't matter. That's a separate ground why there would be no coverage. There is no coverage because the accident took place in Nicaragua. So whether he was maintaining or not maintaining underlying insurance for that, it doesn't matter. Your accident took place in Nicaragua. This policy doesn't cover accidents outside these territorial limits.
And counsel, you're into your rebuttal
Okay.
time. I don't know if you want to reserve.
Thank you.
Okay.
Morning, Your Honors. May it please the court, Mike Brownlee, on behalf of the appellee, Brian Gold. I think the court has a good sense of what's going on here, but there's a really simple way. This idea that the whole duty to maintain is somehow a completely separate issue from the territorial restrictions part of the underlying UN policy. If you look at the your duties to us part of the umbrella policy, the final sentence is, you must maintain your underlying coverage if you travel outside the US and Canada. So right there, we've got at least we have a provision that is envisioning coverage outside the US and Canada. Hence the almost 9 years of debate about what does maintain mean and what are the consequences of the failure to maintain. So respectfully, this idea that you can just segregate these two things and, hey, they've only raised this discrete issue about incorporation by reference. No, the ambiguity started because the provision they sought to incorporate by reference is the territorial restriction. And there's a clause in the umbrella policy that says, under these circumstances, you can have coverage outside the US and Canada. So the whole debate, I don't want to say the whole debate, the majority of the debate for the many years of coverage dispute went through the courts was, was it maintained such that there would be coverage outside the US and Canada? And that hasn't been raised on appeal or challenged, and we're basically just left with these two, I think, pretty clearly conflicting provisions, which is why Judge Turner ruled the way that he did. Does that make sense? Hopefully. If there aren't any other questions, I'll go ahead and sit down.
Okay. Thank you.
Thanks.
Counsel, you have about 4.5 minutes.
Okay. Let's just say that the maintaining the underlying insurance was never raised. Nobody ever talked about that ever. Separate and apart from that, let's just say all we said was, under the umbrella policy, you have to look to the underlying terms and conditions of the auto policy, which was identified, and it says there are territorial limitations on this coverage. This coverage applies in the United States or in Canada. The accident took place in Nicaragua. That's all you need to know all right, let's say that's the only thing we raised. It occurred in Nicaragua. This policy does not have coverage for that territory. That's the bottom line, since whatever the judge found about maintaining being ambiguous has nothing to do with that point. That's why we're seeking reversal. There just wasn't coverage under the umbrella policy as phrased, giving effect to its words and giving effect to the underlying policy that it incorporated.
Isn't the whole concept here that someone purchasing these policies can read the policies and understand what is and isn't covered?
I think that we're at the point where it's for the court to construe them. That if they read the policy, they would read, okay, I have to look at my underlying auto policy, let me see where the coverage applies there.
So you disagree that really the concept here is that consumers can read these policies and understand what is and isn't covered?
I think the consumer can read the policy and see that it's not covered, but it's really the wordings of the policy that are before the court. But that's not a very hard concept. Your coverage applies in the United States and in Canada. That's not hard for a layman to get the idea that, oh, well, I guess if I'm in Nicaragua, it doesn't apply. But we're not, this isn't a reasonable expectations state anyway, but the point is, what do the policies, if you follow the language of the policies and give it effect, leaving aside any irrelevant policy language that we're not arguing over, just the part that we are arguing about, I think it's clear. Look to the underlying. The underlying says territorial limitations. That's why we're seeking reversal. Thank you.